Good morning, WTOB listeners. I'm Dylan Greenwood, managing partner at Greenwood Law.
And I'm Harold Eustache, attorney at Greenwood Law.
And we're here to present to you, For the Record, our new radio show premiering here on WTOB. It's going to be coming to you every Sunday morning, starting at 10:30 a.m. And today we're going to be talking about a very important issue here in North Carolina, and that's self-defense rights. Something that we get called and talked to about all the time, isn't it, Harold?
It is, and it's something that's ever present in the news and in the media, and something that we get a lot of people that want to know what their rights are.
And there are some misconceptions about what those rights are when it comes to the use of deadly force and non-deadly force in certain situations. And one of the things that has been highlighted in fairly recent news is a case out of Raleigh.
And in this case, there was a homeowner who shot and killed a young black man of 20 years old in his yard, and this happened in 2016. The homeowner's name is Chad Copley, and what happened is he called 911 originally to report that hoodlums were racing up and down the street. It was around 1 a.m. in the morning when he made that first call. He said in the recording to 911 that he was that someone was going to kill him before the operator picked up. The victim was named Corin Rodney Bernard Thomas. He was coming from a party just a few homes down from where Mr. Copley lived. And Mr. Copley was charged with first-degree murder.
And that's kind of unique, isn't it, Harold? Because a lot of times with first-degree murder, it's premeditated in some way. And the facts of this case seem like almost a split-second decision on the part of Mr. Copley.
It did, and I think part of it was some of the statements that he made prior to actually pulling the trigger with those 911 calls that kind of went to what his intent was and where his mind was at the time. So just to set the scene real quick, Dylan, these guys are coming down the street. There's a group of them coming from the party, and he is up and he's looking out of the window and he's calling 911. His wife is up as well. When he says that they're coming by his house on the street, would that qualify as something that you would think would make him feel threatened in any way? I mean, can you explain, why he felt that self-defense was a proper claim?
And on its face, just that in and of itself, I wouldn't necessarily think that. But in North Carolina, we do have a couple of aspects of self-defense law. We have the stand your ground doctrine and the castle doctrine. And those are two aspects of the law that do give certain extra rights given reasonable beliefs of imminent bodily harm or that your life is threatened for you to be able to defend yourself. So with the stand your ground law, a person in North Carolina is justified using deadly force, and they don't have to retreat in any way. You get to literally stand your ground. But you have to have a reasonable belief that deadly force is necessary to prevent imminent death or great bodily harm to himself, herself, or another person. You are allowed to protect someone else. And it can also apply if another person is entering your home, your work, your car, and that really ties into the castle doctrine. And so what the castle doctrine allows for is that a lawful occupant of a home, a motor vehicle, a workplace is allowed to protect themselves if there's a reasonable fear of imminent death or serious bodily harm.
Right.
But two things have to be present. One thing is that a person usually a person that received the deadly force had to have been coming unlawfully into that home, that car, that workplace, and that the person who was using the deadly force then has to have knowledge or reason to believe that an unlawful or forcible entry or unlawful and forcible act was occurring or had occurred. And so not only does the person have to enter, but you have to believe that it was a forcible act. So it can't be like Tom Brady down in Tampa Bay that accidentally entered into to the guy's home thinking that it was his offensive coordinator. That doesn't work. It's got to be something forcible. There's got to be a different level there. But it's a presumption, and it's a rebuttable presumption. So it means that, if it did happen that way, but you still went steps too far, you used more than you thought, then perhaps that presumption could be rebutted by a prosecutor.
So in this instance, Mr. Copley, he says that a young man stepped a foot on his lawn, and he's saying that his lawn is his castle, his house and his lawn and all of that is his castle. And he's saying this young man stepped a foot on his lawn, and he believed that they had a weapon. Is that, why did a jury not buy that argument in this case?
Well, first and foremost, they never found a weapon at all. I think another thing that really played into this case was that Mr. Copley was in his home. He fired from a window, so he presumably was behind some form of cover. No one actually entered into the home. At best, the young man entered into something that that we know in the legal sphere as something called curtilage, and that's something that doesn't normally get talked about. But even just one step off of the street into a yard probably doesn't even come into that. So you've got a situation where literally one step on someone's lawn doesn't equate to the use of force in this regard. In fact, the jury instructions that are given to every single juror in the state of North Carolina if self-defense is asserted as a defense says that a person has to enter into a home, enter into the vehicle, enter into the workplace. And so just because you step foot on property doesn't mean that you're actually stepping foot into the home.
Right. And so in this case, this case was compared in North Carolina to, it's called North Carolina's Travon Martin case. And
Travon Martin 2.0.
Travon Martin 2.0. And part of, I think the reason is because Mr. Copley said that he was neighborhood watch. And we've seen this in different cases around the country where someone asserts that they're neighborhood watch and then takes some action. He also, not only did he say he was neighborhood watch, he also said that he was firing a warning shot on 911. So can you explain if warning shots, he said, I'm firing a warning shot as I'm supposed to do by law,
yes.
Mr. Copley said. So can you explain if that's a reasonable belief? Because sometimes we see people saying stuff like that to us, and I think it's worth clearing up.
There's no requirement by law in the state of North Carolina to fire a warning shot. In fact, firing a warning shot has a litany of issues with it. You may fire a warning shot and accidentally hit the person in your warning shot, and there's no way to distinguish whether or not whether it was the warning shot, whether it was the actual shot. You just don't know. And so for that reason, I think the legislature was wise, really, in not making that a requirement that you have to shoot a shot somewhere, anywhere but the person that you're dealing with at the time. So there was a mistake in law there. And, that is what we find a lot with this self-defense stuff. It's very technical. There's stuff that comes about where there are certain requirements that you have to meet for you to be able to use the force that you're using in that moment in time. And so that's why we're here today. We're here to clear all that up.
I know earlier you talked about that the person that is defending themselves has to have a reasonable belief that they're in fear of being killed or serious bodily injury. Can you explain, some instances, what would be a reasonable belief and what wouldn't be a reasonable belief? Because is it just up to that person? Because Mr. Copley's argument is that he did believe this reasonably. So where is that standard?
Well, that's the difference. That's a different, subjective belief versus reasonable belief. Subjectively, Mr. Copley got on the witness stand and said that he believed that his life was in danger. His family's life was in danger. He thought he saw a gun. Well, reasonably, what we know the facts to be were that this individual never entered a home, stepped 1 foot on the property, did not have a firearm in any way, shape, or form, and was making loud noises. Under those set of circumstances, call 911 and let it be it. If someone's coming into your home, then you have the right to institute these things that Mr. Copley took it on himself to do. But a reasonable belief, the clear-cut case is a person's coming into your home, they're looking to burglarize the home, they've got a gun, they come in, bust the door down, you're there, maybe with your family, you see the gun, you are in fear that something's going to happen to yourself, your family, and you use deadly force. That's the clear-cut example. Now, my recommendation is you better make sure they've got that weapon. Because, even let's say that they don't, there would be some scrutiny in that case. I'm not saying that you wouldn't necessarily be able to assert self-defense because of the sheer act of them coming into the home so forcefully. But it's a rebuttable presumption. And that is something that would have to be looked at a great deal. So the clear-cut example, again, would be somebody coming in with a weapon, you see it, you're in fear that something's going to happen to your family, yourself, and you use deadly force.
So on the way over here, we were talking about how this weekend my car got broken into, right? And if, let's say, someone breaks into somebody's car, they're on their property, and you see them break into your car and they're running down the street, and you chase them and you fire at them because, they just committed an act on your property and,
you're
a violent act, you're mad, whatever.
Yeah.
Could that be self-defense? Because
not at all.
They took, you're trying to get your property back.
Not at all. You're not allowed to be a vigilante. At that point, they're retreating. And there's a specific exception carved out in North Carolina's laws, both in statute and case law. The pattern jury instructions that we referenced earlier is a specific context that says if somebody's retreating, they're removing themselves from whatever interaction it is, then you don't have the right to use that force, deadly or not. And that's a big, big issue. So even if somebody enters your home and you're met with a shotgun or whatever else, you decide not to fire. And let's say they get scared and they start dashing straight out the door. Got to get away. And they make it a few steps. You don't have the right to use that deadly force at that moment in time because they have made the clear action to retreat. And again, that is it's a subjective thing that's going to be a fact that a jury would have to determine. But that would really go against you for trying to assert self-defense in the use of deadly force in that moment. So
one of the things, I'm assuming that it matters if somebody was the initial aggressor in the interaction. Let's say for stand your ground where it's not at a home, because stand your ground could mean any place that a person could lawfully be. So it could just be, in the parking lot or wherever.
As long as you're allowed to be there.
As long as you're allowed to be there. So if a person, let's say they get into somebody gets into an altercation, does it matter who the initial person that throws the first punch is? Does that matter in self-defense?
A lot of times it does. Now, again, like anything in the law, there are exceptions, and there are exceptions to the exceptions and to the exceptions. But generally speaking, if you're the aggressor, you don't have the right to assert self-defense. It even goes so far, and there's case law on this, that if you start mouthing off to the point to get someone to fight you,
right,
that can just nullify your ability to use self-defense as a defense if there were to be an altercation that takes place.
So you can't go up and say, your mom, blah, 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 and then the person attacks you, and then you're saying, oh, no.
Yeah, and you're evoking that person, come at me,
right.
Let's do this, let's toss. No,
okay.
Not at that point. And that, now, again, the exception to that is, even if you're the aggressor and the other person opposite you, let's say it's a fist fight, and all of a sudden they take it up and they pull a gun out, and they put you in threat of your life, then you're allowed to assert self-defense as a defense at that point because they've taken it to a whole new level by pulling that gun out.
And when you bring that up, it makes me think of the Travon Martin case, because part of the argument was that even though George Zimmerman, who, if you guys remember, George Zimmerman was the person in Florida near Orlando who said that he was part of a neighborhood watch group, and he was the initial aggressor in approaching Travon Martin as he was walking home from a convenience store. Now, it's kind of undisputed, I think, that George Zimmerman was the initial aggressor in the sense that he approached Travon Martin. But what was disputed is about what happened afterward. And there's some accounts that Travon Martin, in this kind of fist fight, got the best of George Zimmerman. And at that point, George Zimmerman felt that he was fearing for his life.
So, Harold, given that set of circumstances, how was George Zimmerman able to assert self-defense in the Travon Martin case juxtaposed with what we have in the Copley case?
So part of the reason that he was able to, even though he was the initial aggressor, is because there was some evidence, and again, there was not a ton of evidence in the Travon Martin case because George Zimmerman was the only person alive that was there for the entire incident. But there's some evidence from the initial officers that reported and a couple of eyewitnesses that saw some of it that Travon Martin did get the best of him in that altercation, in that fist fight. And so George Zimmerman did sustain some different wounds to his face. And the account that George Zimmerman gives is that he was being bested by Travon Martin, feared for his life, and eventually pulled out a gun and shot Travon Martin because Travon Martin was covering his nose and mouth. And so in that instance, it is different from the Copley case because Mr. Copley was never in some sort of physical altercation with this young man that he killed. This young man never got close to him. He was, again, like you mentioned earlier, he was behind a garage door, shot him from a distance on that yard and killed him there, whereas Travon Martin and George Zimmerman were fighting in a very, very close scenario where that was a point-blank shot that when George Zimmerman pulled out his gun. So part of what happened was the jury did have it's not that they had enough evidence to say definitively that what exactly happened, but they had enough evidence to basically have reasonable doubt as to whether George Zimmerman had malice in killing Travon Martin, and they had enough to believe George Zimmerman's story that Travon Martin got the best of him in that fight and was able to assert self-defense. One other quick thing is that the defense in George Zimmerman's case, in Travon Martin's case, they had a choice between going for stand your ground and self-defense. And in Florida, what they did was they waived their hearing for stand your ground at the beginning of the case, because if they would have won that, the case would have been thrown out. They instead decided to go for a self-defense strategy.
And that's different here in the Copley case, where they used stand your ground that then bled over into the Castle Doctrine and try to combine those two legal theories as a way to assert self-defense. So it added a level of complication, I think, to Mr. Copley's case, even with the facts being the way that they are. It does make it quite technical, especially for a jury, to try to weed through all that and figure out exactly what law to apply and how to do it. If you're just joining us here on WTOB, this is Dylan Greenwood and Harold Eustache for the record with Greenwood Law, and we're discussing self-defense rights in North Carolina, and we're discussing the Copley case that just this year finally finished out after all of the appeals and everything that it went through. Case that happened in Raleigh that was basically a lot of people dubbed Travon Martin 2.0. And we've been discussing all the different aspects of self-defense here in North Carolina. And the next thing we want to discuss is that there are different types of self-defense. There's perfect self-defense, there's imperfect self-defense, and then there's just no defense to self-defense. And Harold, what is perfect self-defense? What happens in those cases?
What happens in those cases is where somebody is an aggressor toward, let's say somebody is an aggressor toward me, and I'm just minding my business. They come up and, start assaulting me, and I have to use force against that person to stop that assault. And I have a reasonable belief that that my life is in jeopardy, or that I'm going to get some serious bodily injury. An example of that would be, I'm at home watching TV, somebody bursts into my house with a gun, and I pull out a gun and shoot them, right? Because they've already showed that they went into the house, they had a gun. I reasonably could fear for my life or my safety. And I used force against them that was appropriate.
So it completely exonerates you because the use of force was reasonable and you used a reasonable amount of that force. Is that fair to say?
That is fair to say. So it does, in courts have said it does matter, all these sort of circumstances about, who that aggressor is. So, you would have to take all that into account into how much force is reasonable to respond with. But again, if it's a situation where a person is, we're in the Walmart parking lot and some fighting words are used and they punch me and then I pull out, a Mossberg shotgun and shoot them, that would not be a perfect self-defense because the force was excessive given what the aggressor did.
So would that possibly be an imperfect self-defense case?
It would be an imperfect self-defense case because even though I had the right to use defense, the amount of force was excessive. And that would be an example of where a jury would have to look at, or jury or judge would have to look at whether or not there was the right amount of force used. And we see these and these facts are taken into account a lot of times in domestic violence cases that we see, where a fact finder is looking at whether or not this is appropriate amount of force, sometimes not just for that one occasion, but courts have said you can look at what the past history of the two people that are interacting is to know whether or not that use of force when you're defending yourself is reasonable.
Right. And, I had this in a case last year where it's actually a bar fight and my client went a few punches too many. He had the right to respond the way he did initially, but then in a split second, all of a sudden the other person started to retreat and my guy kept going. So all of a sudden it crossed over into the use of force, whether or not it was reasonable. It really literally was a punch or two too far. And in part, that case inspired us to come and talk about these particular issues because, self-defense doesn't just apply to lethal force. It applies to non-lethal force too. And it applies just as fervently because, we do see these cases outside of the use of lethal force more often than not. And it all comes down to whether or not you had the reasonable belief to use the force. And if you met that use of force with equal or lesser force, you can't use too much of the force because once you do, all of a sudden it either becomes an imperfect self-defense case or you just don't have the ability to use self-defense as a defense for the charges because, let's say all of a sudden you become the aggressor or someone's retreated, then it just takes that ability right away and you don't get that protection any longer.
It really does, and that reminds me, one of the things in the Copley case was that the defense tried to put on initially in pretrial motions that to talk about the background of the victim. And so the reason they did that is because they wanted to say that Mr. Copley had reason to believe that the victim had knowledge of firearms, had prior altercations with other people, and that made it reasonable for Mr. Copley to fear for his life. Well, the judge denied those motions and didn't allow that evidence to be presented at trial. And part of the reason was because Mr. Copley didn't know the victim at all, and didn't have any prior knowledge of who the victim was. So that matters on both sides. So it does matter if you have prior knowledge of that person as far as your reasonableness about whether or not to use to defend yourself. If you're just joining us on WTOB, you're here with Attorney Dylan Greenwood and Harold Eustache of Greenwood Law. This is For the Record. We're discussing self-defense, and on the phone with us we have a good friend of mine, Rob. Rob and I served in the 101st Airborne Division together in the infantry. We did a deployment together in Afghanistan. And now Rob is a law enforcement officer in St. Louis, so he served his country, which we thank him for, and he's still serving his community in St. Louis. So, Rob, are you there?
I am.
And so, one of the things in the news recently has been that there was a couple in St. Louis area that was on their lawn. Very famous picture in 2020 with weapons. I think there was one AR-15 and a pistol, and they were responding to a crowd that had come near their property. Can you talk about that a little bit?
Most importantly, Missouri has the Castle Doctrine, which is, when you lay your head, you can defend yourself at. So it's either your home, your car, let's say it's a tent. You have the right to defend yourself. We also have a stand your ground law here in Missouri. So there is no need to basically make an effort to withdraw from a situation. The fact of the matter is these people were outside. We don't know at this time still if anyone was armed in that crowd. There could have been armed. People have been known to be armed. We've seen it. Just in fact, the other day we had an individual who was standing with a couple of his buddies with ARs at the bottom of a parking lot, not on our police property, but on the sidewalk on the street, just to show their presence there. And me being a veteran and a huge Second Amendment advocate, I'm fine with that. I believe that anyone should be fine with it. It's your God-given right if you want to do that. If you take it past that, that's a whole different story. Thankfully,
and do you have any instances where someone has taken it past that?
Yeah. To sidestep your original question, I do have an instance of that. At work, I had a gentleman that responded to a call. The gentleman said that there was a man standing in the street with a firearm, holding what looked to be three teenage boys at gunpoint. So, of course, we responded accordingly with more than a few calls. Got there, got on scene, took control of the scene, actually spoke with the gentleman, told him, lower his firearm. At that time, we were asking what was going on. No one was shot. We had three teenage boys that were afraid. And upon speaking, we separated the two parties. So I spoke with a gentleman who was basically brandishing the firearm. And I was like, well, what is going on today? What happened? What took place? And he was like, well, a week ago, I saw three boys that matched the description of those three right there. They had broken into my car, and I saw them walking down the street. So I came out of my house, and I pointed my gun at them. I knew it was them. It had to have been them. It was three boys, and just saying he's off his property across the street, holding three boys at gunpoint.
In that instance, that wasn't self-defense, is what I hear you saying. And even though he may have believed that it was these kids, that going across the street seemed like it was too much. Do you have any advice for citizens and how they should handle these kinds of situations in your experience?
In going forward with saying, like, having a firearm and defending yourself, though, if you're going to draw that firearm, it needs to be the absolute last thing that's happening, correct? I mean, at this point, I fear for my life. I fear for the life of my loved ones, and I need to stop the threat. I have to stop the threat at this point. I feel threatened. My life is threatened. It's not three boys walking down the street.
Again, we appreciate you and what you're doing and your service to both the country and your community. and your advice for our listeners today.
Yeah, thank you very much, Rob.
Gentlemen, I appreciate it very much.
Listeners, thank you for joining us today, and don't forget to join us next Sunday at 10:30 a.m. here on WTOB. For the record, with Greenwood Law, we'll be discussing Cuties, the Netflix distributed movie, causing quite a ruckus around the country. But before we go, we're going to leave you with some words, and don't forget the Greenwood Law Bill of Rights. First and foremost, I will not represent myself in court. Number 2, I will not do law enforcement's job for them. Number 3, I will not make statements when stopped by law enforcement. Number 4, I will not consent to searches when asked by law enforcement. And number 5, I will not be my own star witness for the prosecution.
Remember, everyone, it's not a crime to know and assert your rights. Stay informed, stay safe. This is For the Record with Greenwood Law, signing off.